more on this.
I'm calling Jan Logie.
Thank you, Mr Chair. I was to take a call on the committee stages of the Children, Young Persons and Their Families Advocacy, Workforce and Age Settings Amendment Bill. And this is a bill that we've been quite clear we are unable to support in its entirety. There are specific provisions in the bill, however, we are very happy to support if they were all that was contained in this bill. So in my contributions this afternoon, I'd like to go through some of those specific provisions and talk in a bit more detail to them, the lost opportunity that we see in some and the very real concern we see in others and the sense of hope in others again. So first of all, I would like to speak to the commencement date, which is clause 2, that this bill is intended to commence on the 1st of April 2017, which is set to coincide with the start of the new ministry, which has been so poorly named, the Vulnerable Children's Oranga Tamariki Ministry, which has raised very significant concerns in the community. And I think the point has been well made that actually oranga, in terms of well-being, is cancelled out by the concept of vulnerability. And to put those two things together in the title is misunderstanding the concept and actually wipes it out in practice. So we have concerns with that. And it does need to be understood that what this legislation does is not a mild tinkering with our current child protection service. This is a potential dismantling of the state care and protection services. And that is enabled by this legislation. But there is very little detail in this legislation, and as was pointed out by some of the submitters to the committee, I think the phrase from the Commissioner for Children was that it seemed that the legislation had outstripped the policy process. It may have been put a little bit more eloquently than that, but basically saying we've got legislation that enables anything to happen because the policy work hasn't actually happened to work out what this will mean in practice. So we are being asked to pass legislation that provides for our protection of children that have been hurt and damaged without knowing actually what that's going to mean in practice. And that this is going to come into force by the 1st of April. I do think that that commencement date and the time frame for this is really important to consider, because while I have been pushing for changes and more money to be going into the system and more urgent action for a long time, as have others on this side of the House, because we know that kids right now are unsafe in the system as it's operating, and the Office for the Commissioner for the Children doesn't have adequate funding to be able to provide oversight of the safety of the system. While saying all of that and the need for urgency, if the policy work hasn't been done to make sure that we get the right answer, to make sure that we've got a system that will protect those children, then it's not right. Because that actually really has to be our first priority, and we have to put the thought into that to make sure that we are not making mistakes. And the Green Party is not confident that that work has been done. So now to move on to speak to some of the other points that we do support in this legislation. We do support the raising of the age of care and protection to 18. you know, this again is one of those things that has been asked for, Mr. Chair.
Logie.
Thank you, Mr. Chair. That has been asked for a very long time. And I sat on the Social Services Select Committee when we considered the Vulnerable Children's Bill. And we heard from young people that had been transitioned out of care at a time where they were not able to be able to sign a lease on the flat, on a flat, to be able to live independently, and ended up homeless on the street. At that time, it was really clear to me that we needed to raise the age of care and protection to 18. Yet this government chose not to do that. And here we are, several years later, finally, after several opportunities have passed, finally giving this House the opportunity to act on that call from those young people, to be able to provide that smoother transition for those young people into the next stage of their life. And that is really critical. However, as has already been pointed out by Labour's Jacinda Ardern, that it is nonsensical from our perspective to be raising the age of care and protection and not raising the age for youth justice as well. That these are often, as we were told time and time again by the submitters to the Select Committee, the same young people. Many young people in our society who have youth justice concerns have been in care, are in care at the same time. So to say, if nothing's going wrong, you're a young person, but this half of you that did something wrong is an adult, it just doesn't make sense. And New Zealand is lagging behind internationally in understanding this. We have an exception in place on the United Nations Conventions on the Rights of the Child that is an international agreement that puts the onus on us to recognise that our young people are children until the age of 18, regardless of whether they have committed crimes or not. And this isn't to say that our system doesn't hold those young people to account if they do something wrong. Youth justice responses are actually more effective than adult justice responses. So this is not about, you know, giving young people a pass. This is actually about recognising that they are children. This is about having an effective system that is consistent and sets out consistent expectations and responses. But it's also just about what's effective. And it was really compelling to hear from the new Commissioner for Children, and I think it was his first submission when he got to present on this. Previously, the Principal Youth Court Judge telling us how effective the youth justice system is and how much more benefit it would be for all of us, and especially those young people, if we extended that age to 18. So we will be very happy in the Green Party to be supporting the SOP 248 in the name of Jacinda Ardern, to be able to define young person as and remove the, replace 17 years with 18 years to be able to get that consistency in our system. It really needs to be done. It should have been done before. And it is, frankly, for me, embarrassing that New Zealand is one of the last countries in the world still treating our children as adults in the justice system. So I don't have that much more time in this call, but I would like to just also say that we will be supporting the other aspect of Jacinda Ardern's SOP 248, which adds a little bit more grunt to the aspect of the bill that embeds the views of young people and children into the system, and requires publishing annually after the first anniversary commencement of the date how the views of children and young people have been given to regard to and changes in the system. There is more that we perhaps would have added to this, but this is, I think, just taking us a little bit more further in the giving the intent that's been specified by the Minister previously of the purpose of this bill.
I call Alfred